Oh, well, it is great to see you. Good.
Busy? For sure.
Yeah. So how are you?
I was looking in the settings to change the webcam contrast, and it wouldn't let me do anything. It didn't
I
update.
had to install the webcam.
Oh, yeah, that probably helped.
Yeah. But I didn't see anywhere in Wirecast like
Um, I think it's in the sources control panel or something. It'd be a fly. Yeah, I don't think that does anything. But you should bump that up to 1080p, just so that it's the best resolution. Oh, didn't realize what happened. Oh well.
sorry.
I don't know.
All right, if I can get everybody's attention here, we figured we should start on time, that way we can finish on time. But feel free to have lunch if you haven't grabbed it yet. But we are quite honored to have with us today on Constitution Day, as we talk about immigration and the Constitution, three really distinguished speakers. What I will do is spend 2 to 3 minutes maximum introducing the three of them, and then I will turn it over to them to speak. We might have a little bit of discussion, and the last 10 minutes we will reserve for questions and answers. From 15 minutes, 10, 15 minutes we'll reserve for questions and answers from the audience, and attempt to finish up by 1:30 to meet all the speaker schedules as well. Okay, so our first speaker is going to be our own Professor Sheila Velez-Martinez, who'll be giving us sort of an overview of the way in which constitutional issues affect, in which immigration, constitutional issues have an effect on immigration law. It's not something that's constantly always understood or appreciated, but in fact it is quite important. Professor Velez-Martinez is our clinical, she's acting as director of the clinical program generally, but she's also she's been an immigration clinical professor for some number of years, and in addition to her exemplary work as a clinician, she has been doing a great deal of scholarship with respect to matters that relate not only to immigration, but also to things like remittances and the like, including within the United States or its territories, such as Puerto Rico. Vic Walczak has been an attorney for over 30 years, public interest advocate, highly respected works for the ACLU, has been doing a number of immigration cases. The two most prominent involve the city of Hazleton, and the one that he'll be talking about today, which is the city of Lancaster, that he's been doing on behalf of the ACLU. He'll be going last to talk about that. In between, we will have a firm lawyer, for those of you who are students and interested in working in firm law and in the world of immigration. Our own Pitt law graduate, Kate Trebecki, who, while she was at Pitt, distinguished herself in any number of ways working on international programs, including flying off to Bahrain and training a bunch of students on how to do international arbitration work. She now works in immigration, and she will be able to offer us a sort of on-the-ground description of how immigration tends to work from a lawyer's perspective in the ways in which constitutional issues have some implication on them. So with that, I will be quiet, stuff my mouth with food, and let our speakers take it, the two experts take it away. So Shayla, go ahead.
So welcome. It's great to have a full house and great to be here. I think there's been a great deal of discussion recently in the media regarding the United States, the executive power of the President of the United States regarding immigration, and general controversies between the federal government and the states regarding immigration law. So you probably have read U.S. versus Texas, U.S. versus Arizona, and the several others different levels, and that has been part of the ongoing conversation regarding immigration law in the United States recently. So what I want to do is to give a little bit of background on how there's this entanglement and historically problematic relationship between immigration law and the Constitution. So we're going to be talking about 19th century, 20th century. I see you guys nodding for those of you that are looking at the PowerPoints, which is kind of a historical journey throughout U.S. immigration law in cartoons and posters and pictures, and that's most of them I'm going to make some reference to. So we are used to thinking that immigration law is the exclusive realm of the federal government, and certainly in U.S. versus Arizona, the Supreme Court of the United States highlighted that indeed it is a realm that is preempted and it's the federal government's arena, to say that. But it was not always that way. And because at the beginning of the United States, around the first, close to first 100 years, the policy of the United States was an open borders policy, and it was actually the states who dealt with immigration. So you can have the states excluding or removing a citizen to their own state because that citizen was a vagrant, a prostitute, or a lunatic. So vagrants, prostitutes, and lunatics are a permanent worry of immigration law when immigration law was regulated by the state, and they still are a worry for current immigration law, as all those are grounds of either exclusion or deportation from the United States even today. There is no constitutional clause that expressively delegates immigration power to the federal government. So this immigration power is really a creation of the case law of the United States Supreme Court. And it all started with the Chinese exclusion cases. And you will see that although we call it immigration law historically, we should call the immigration law of the United States the exclusion law of the United States. Because the history of how this act came to be was really through a series of statutes that were designed to exclude foreigners. So at the beginning, we had the Alien Sedition, the Aliens Enemy Act, and the Sedition Act, and the first comprehensive immigration law, well, the first federal immigration law was the Page Act, was designed to exclude Chinese laborers that were present in the United States. And that continued then in what is called the Chinese Exclusion Act, that said, regardless of whatever treaty we might have with foreign country, meaning China, as to who can come to the United States, we are hereby excluding Chinese entrants from the United States. And it's interesting because the exclusion of Chinese immigration to the United States continued until the 1940s. So that was a staple of the immigration law in the United States. Why is then, so if there's no constitutional clause that expresses that it is the federal government's power to regulate immigration, how come we have a federalized immigration system? But what the Supreme Court has said over and over again is that this is a power that is inherent to the sovereignty. So every sovereign nation has to have the power to regulate its borders, who comes into its country. So it's a power that comes from being a sovereign nation. The problem with that type of power that is inherent to sovereignty is that it's more difficult to check, to put into check. And historically, the Supreme Court has had a lot of deference to the Immigration Act and a lot of deference to what the federal government has tried to do for purposes of regulating foreigners because of that. And many of the slides that you see makes reference to the Chinese Exclusion Act, make reference to the Japanese internment camps, make reference to the exclusion of people on the base of their religion, which is, my son familiar, right? And exclusion of people of getting citizenship because they were not white males. And that was validated by the Supreme Court. And why? Because there's this deference. Why? Because this is inherent to our sovereignty as a country. The United States immigration law, until the 1960s, was a law based on national quotas. What does that mean? That only people from certain countries could legally immigrate to the United States, and those quotas were set by percentages that reflected the people that were already here. And the northern you were in the European map, the more likely you were to be able to immigrate to the United States. That changed in the 1960s to a system that is very similar to the system that we have today, which changed the priorities of immigration from an ethnic quota, nationality-based quotas, into a family-based, employment-based quotas that we have today. So the system that we have today in place reflects the needs of the country in 1965. And I think Kate is going to talk to you about how effectively and beautifully that plays out in 2016, or it doesn't. The states were, at the beginning, regulating immigration and seem to have pretty much accepted this new role that the federal government had in regulating immigration. And although there was some initial litigation regarding whether the states could tax passengers and what role could the state had in regulating immigration, until today, it was pretty clear that this was a federal government role. It's in the 1990s, states began filing lawsuits against the federal government, saying that the federal government was violating their guarantee clause, and they were violating their duties. Do you know what the guarantee clause? So they were violating the duty to guarantee a Republican form of government. And they were violating the duty against protecting the states from invasion. And those were all constitutional duties that the federal government has toward the states. All of those lawsuits, New York, California, Florida, Arizona, the 7 states that had the largest number of immigration, what they were basically seeking from the federal government was reimbursement for the cost of housing the largest immigrant communities in the United States. Those lawsuits were all dismissed during the 1960s. And that takes us to today. And the litigation regarding US versus Arizona, what that is a litigation filed by the federal government to enjoin Arizona's adoption of a legislation that sought to change the amount of, I'm trying to say it in a very polite kind of way. But what the litigation, what SB 1070 was looking to do was attrition through enforcement. To have the immigrant communities that were in Arizona voluntarily leave the state of Arizona because it was so difficult for them to live in Arizona. So it was called attrition through enforcement. And the United States Supreme Court eventually enjoined the most controversial parts of that legislation, but there was a counter lawsuit by Arizona saying that the federal government was violating the take care clause. And the take care clause means that the president has a duty to enforce the laws of the country. And that issue is also part of what was filed by the state of Mississippi in a case called Crane versus Johnson. Crane has 3 or 4 parts, also seeking to force the US government to do certain things that the state thought were necessary. For example, more border patrol agents, more money, more resources, more enforcement. One of the lawsuits actually demanded that people were arrested and no prosecutorial discretion was issued to any person that was undocumented in the United States. In deciding US versus Arizona, the US Supreme Court recognized something that is extremely important for the next stage of litigation, that is that part of the power of enforcing the immigration law by the president requires an enormous amount of discretion. That it is the executive branch that would decide who gets deported when and the manner of the execution of the deportations. And that is part of the controversy in the Texas litigation, because since we have the same immigration law, basically since 1965, there has been an enormous amount of pressure to revamp the Immigration Act and have what it's called a comprehensive immigration reform. And in 2013, the US Senate had a bipartisan team that adopted a bill that was sent to the House and died in the House forever. And as a response, the executive branch issued in 2015 an executive action on immigration that extended protection from removal and allowed people that were in the United States for a long time and had children that were legal permanent residents or citizens to remain in the United States with employment authorization. And it also extended the deferred action for childhood arrivals that was already given to children that have been brought in the United States by their parents when they were kids. And that is the subject of the litigation in the Texas case, that whether the President of the United States has the authority to issue a prosecutorial discretion rules, that's what they're saying, that this is a rulemaking really, to benefit close to 3 or 4 million people. And whether this deference that has been recognized to the federal government in the exercise of the immigration power, that is a representation of their sovereignty, extends to that sweeping discretion. The case was filed in Texas in Judge Hannon's courtroom by miracle, apparently. Not really.
It's called forum shopping. Yeah.
I didn't say that. He said that. So after some of that, a Texas district court enjoined the prosecutorial discretion for the parents of children and for childhood arrivals, and it was also enjoined by the Fifth Circuit. And when it went to the Supreme Court, because now we have an 8-member Supreme Court, it was a 4-4 decision, so the decision of the Fifth Circuit stood. That doesn't mean that that case is it's over. What it means is that the injunctive part it's over. The case continues to be litigated in Texas at the district court level, which means that there's not a lot of hope and on the merits of that decision in district court. But this is not, I mean, this is not the end. This is part of a conversation. And from my perspective, the issue of immigration reform is not to be litigated. This is an issue that requires a meeting of a societal values. So we need to get into an agreement of what do we want as a nation regarding our future. Because the conversation regarding immigration law has always been about what is to be an American and what is American to be. That is why you see all those flyers, exclusion. So if the US is to be the pluralistic society that I think is what makes it strong, this conversation about comprehensive immigration reform has to happen, and not necessarily has to happen in the courts. It has to be a meeting of societal values for us to go forward.
Thank you, Shayla. Kate, why don't you take it away?
Okay. I thought that I would give sort of a very broad overview on how people immigrate to the United States, how to come here, quote, legally. As Professor Velez mentioned, our current structure is that you're sponsored by your family or you're sponsored by your employer. And then within those two categories, it's broken down even further so that children of US citizens get first preference, children and spouses of lawful permanent residents or green card holders get second preference, and kind of down the line. On the employment-based side, we give sort of a fast track to people who have extraordinary ability, who are outstanding researchers, or who are multinational executives. And then underneath that, it goes further still, so that if you've got a master's degree, then you're in another category. If you've got a bachelor's degree, you're under that, and then basically everyone else under that. So just to give you an idea of some of the wait times, if you are the unmarried child of a US citizen and you were born in Mexico and your family files for you, you are looking at waiting. Your family had to have filed for you before April 1st, 1995. That's how long it's taking for these to become current, because there are so many more applicants in that category from Mexico than there are visas available. Other pretty bad ones are children of Indians are waiting from September 9, and then, 2009. And then on the employment side, which is what I deal with a lot more, in September, for the first time ever, that first base category actually fell back for Indians and Chinese nationals. Yeah. That means that our professors, our scientists, our researchers, our artists, our entrepreneurs from India and China are having to wait now 2 or 3 years. Now they came current again in October, so it wasn't an issue. But the fact that they even fell back, for a month is a big deal, and it causes worry among employers and among immigrants. So along with those wait times comes a lot of uncertainty for both families who are sponsoring their family members and for employers who are sponsoring their employees. Family members are waiting apart from their family for all this time because it's often very difficult for the person waiting abroad to get a visa to even come visit, because they assume that if your family member filed for you, you're not going to come for a visit. You're going to come and park it and stay. So they're often separated for many years at a time. On the employment-based side, there's again a lot of uncertainty, especially with the current political climate and some of the proposals that have been made. From the employee side, there's a serious lack of mobility and flexibility once they're here. When their employer sponsors them, for a long period of time, they're sort of, for lack of better words, stuck with that employer, and sometimes even in that position that they've been sponsored for. So it makes it very difficult for them to grow in their careers and continue to move up. So there's also a serious cost issue for employers. I mean, these are not inexpensive. It's not inexpensive to petition for your employees. And a lot of what we see, especially with the CMU spinoffs and Pitt spinoffs, is that these employers are tiny little startups that are doing their thing, and they work with someone from the time they were a student until they get a temporary visa, and then they want to keep them here forever and sponsor them permanently. They've invested a lot into that employee, and if they're looking at it not working out in the future, or it being a really long time before that person is guaranteed to be able to stay here, well, that kind of makes you change your cost benefit analysis with that employee. So it's when people talk about, oh, they should just wait in line with everyone else, I just wanted to give you guys kind of an idea of what that line can look like for some people. It's not easy, and again, from employer side, we do see people who can't find people to do the jobs that they want them to do, or like I said, they get them from when they're a student and they're integrally involved in this small business or whatever the case is. We recently worked with a landscaping company in the area who every single year he pays, between filing fees and legal fees and everything, he easily pays probably $30,000 or $40,000 to bring 5 Jamaican workers in to work for his landscaping company, because the U.S. worker, and he's paying them pretty decent wages to be out in the Pennsylvania sun doing landscaping work. I know it's brutal. The U.S. workers he hires either don't show up, or they show up under the influence, or they come for a day and don't come back, whatever the case is. So for him, he's had these guys coming in for probably 10 years now. He knows they're coming, he knows they're showing up, he knows how to get them here, and for him, that's worth it. So they're temporary, he's not sponsoring them permanently at all, but that's sort of the analysis that people are going through as they look at whether they want to sponsor someone temporarily or permanently, or even go through the process at all.
All right, so I thought I'd give you a war story from the trenches, and it's actually a live trench with raw sewage flowing through it. We just filed for a second emergency injunction about an hour ago, so let me tell you a little bit about what's going on here. So in mid-April, we get a call from a refugee resettlement manager in Lancaster, Pennsylvania. And she says, I think there's something wrong here. So, okay, well, what do you think's wrong? And she says, we're getting these older refugee students, and when we're taking to enroll them in school, the school district in many cases is telling them they can't enroll, and that they should go to Job Corps, they should go to Literacy Council, they really should be working and earning money for the family, and just outright refusing to enroll them. Now, in Pennsylvania, you have a right to go to public school until your 21st birthday. Okay, they're all under 21. And then if the refugee resettlement folks kind of press the school district and say, well, I thought they had a right to go to school until they're 21, the school district is delaying, sometimes months. So if they come in March, they may say, well, it's kind of late in the year, you should probably wait until September. And then if the resettlement workers continue to press, they don't send them to the regular high school. You gotta understand, Lancaster has a regular high school. It has for a long time been a large magnet for refugees. We think it's because of the Mennonite traditions there, but they've had very vibrant refugee resettlement efforts going on there for decades. So in fact, about 15 years ago, they developed a program at their regular high school called McCaskey, which is known as the International Program. And it's designed for newcomer English language learners, or people who don't speak English very well, and they even have a sub-program for students who come over here who have limited or interrupted formal education. Right, so you got immigrants who come over in very different stations. You got some who come over and they are, diplomats' kids or financial executives' kids. They may be from China, from India, from France. May not speak English, but they've had formal education. And often these kids will pick it up just like that and end up in 3 or 4 years being the valedictorian. The refugees are very different. The ones that we're working with come from places like Democratic Republic of Congo, Somalia, Sudan, Burma, Nepal, and they've had very little, if any, formal education. And this school is specially designed for them. But the school district of Lancaster says, sorry, that door is closed if you're 17 to 21 years old, because we're not sure you're really going to graduate. And they haven't expressly said this, but this is actually what the court found recently, that they are concerned about their graduation rates at the high school. So, schools are kind of measured by their graduation rates, and if they go down, you could be a distressed community. There's all sorts of oversight. There may be financial implications. And about 5 or 6 years ago, the superintendent in Lancaster decided that he was going to really fix the graduation rates at McCaskey. So he did a number of different things, and he won all sorts of acclaim for improving graduation rates at McCaskey. In fact, he won so much acclaim that a year and a half ago he became the Secretary of Education in the Commonwealth of Pennsylvania. But back to Lancaster. So one of the things we found out that he did was that these English language learners, most of them are refugees, some of them are what are called entrants from Cuba or Haiti or Dominican Republic or Ethiopia. What they do is they put them in a different school, a school that is run by a contractor, Camelot, which typically runs alternative education programs for disruptive youth. But this is not one of those schools, or at least they claim it's not one of those schools. It's an accelerated credit program where you can actually get twice as many credits. So in 2 years, you can get 4 years worth of credit. And it's a beautiful thing. And just imagine you're a refugee, you've been traumatized, and every day when you come in, you are not allowed to bring anything in or out of the school. No books, no backpacks, no writing utensils, no papers, obviously no homework, which is a great thing unless you really want to learn or need it to improve your English. And when you come in, there is a hand pat down. And it's not one of these, it's all over. You got to take your shoes off, you got to shake them out. They have something called behavioral specialists in the school, which are sort of like school resource officers, but most of them are former correctional officers. And we've had reports of a lot of staff on student brutality. And frankly, a lot of the kids in this school are troubled youth. So this is where they send refugees. So we investigated. This came in April, and we lined up 6 students who are so unbelievably sympathetic and wonderful. The first one that we got involved with is a young man named Kassim Hassan, who's from Mogadishu. And when we first went to meet with these kids, I'm thinking, there's going to be a really rich background, which is going to look great in the federal court lawsuit. And you talk to these kids and say, well, tell us what was life like in Somalia? It was okay. It was okay. Well, it wasn't very good. Well, tell us about it. It was kind of sad. And that's like all we could get. And then over the course of 4 months, as we're building to trial and you get to know them, you learn more about their stories, and you find out that in fact the father is on the wrong side of Al-Shabaab. You find out that a weapon fell on their apartment while they were all there, killing the father, injuring everybody else, that they hid in the bush for 6 months so as to not get killed. They finally make their way to Egypt, or we have a Sudanese girl who spent 12 years in a refugee camp in Chad. I mean, it's just, unbelievable stories that these kids have gone through. So we send a letter to the school district and say that this is not a good place for these kids at Phoenix for many reasons. One is they're not learning anything, right? They're not getting the state mandated amount of English as a second language. The classes are taught twice as fast. Now, that may be great if you speak English and just want to get credits and get the hell out of there, but if you don't understand English, right, and you do it twice as fast, How well is that going to work? Well, according to the school district, it's going to work great, and they're still saying that. So we sent a letter to the school district, and you know what they said in response? Neither do I, because they never replied. So we sent a spoliation letter, and we got to work. And in mid-July, we filed a federal court lawsuit. And you think, what are the claims? So you look at a situation like this, and you think, you know, this is just wrong. I mean, it is wrong on so many levels. But how is it illegal? So, you know, we got a little bit creative. First of all, clearly you have a right to go to school until your 21st birthday. Right? That's a state law claim. Unfortunately, about 40 years ago, the U.S. Supreme Court has said that there is no constitutional right to an education, U.S. constitutional right on our education, so that's not an available claim. But fortunately, there is a really nice statute that Congress passed back in the early 1970s called the Equal Education Opportunity Act, which actually says that school districts have to provide programs for English language learners that help them overcome their language difficulties so that they can access the regular part of the curriculum. Really good law. We also filed under Title VI and the Equal Protection Clause, both of which actually require you to prove intentional discrimination based on national origin, which is almost impossible to do. We actually, I think, may be able to do that in this case. And we made a due process claim there as well. I kind of thought, you know, very few cases go to litigation, and about 75% of the cases we get where we send a letter or make a phone call, the defendant says, we uncle. This school district didn't. And we drew a judge. We filed in the Eastern District. We drew a judge from Easton, Pennsylvania. There's only one judge in the Eastern District who sits in Easton, and by luck of the lottery, we're in Easton. It's 5+ hours away. I know that because, and I can tell you exactly how to get there and how to get back because I've now done it many times. The judge was wonderful. He allowed us to do expedited discovery. We took 17 depositions. The next week we went and began a 5-day trial. And on August the 26th, the judge granted a preliminary injunction and ordered that the school district allow all of the named plaintiffs to go to McCaskey. And what he found is, I mean, we had an expert who came on and said, what everybody knew intuitively, that if you don't speak English and you do it twice as fast, you're not going to understand anything. So you know, we spent thousands of dollars on an expert to come in and say what everybody already knew intuitively, but that's how the legal system works. So the judge relied on that. He also found they violated state law by denying enrollment. He enters this injunction. Now, we had filed this as a class action lawsuit. The judge was reluctant to certify the case as a class action. And so what he did in his memorandum and then in his order is said that he's deferring ruling on the class action. And in the court order, where he orders the defendant to allow the plaintiffs to go to the better school, to McCaskey, he drops a footnote and says that he is encouraging the defendant to honor the ruling for similarly situated students. I gotta say, I mean, 99 times out of 100, you would expect that the defendant is gonna get the message. So we immediately call the school district's lawyers and say, you know, please share information with us about similarly situated individuals. And for a couple of weeks, they essentially refuse. Eventually, the judge pressures them to give us information. It turns out to be incomplete. And starting last week, we get information that, in fact, the district is taking the position that they will apply this order only to kids who are actually at the crappy school at Phoenix on the day of the court order. So we now have 4 kids who have come since the court order that have been refused permission to go to McCaskey. In the meantime, the school district has filed an appeal to the Third Circuit, and preliminary injunctions are subject to an interlocutory appeal. Earlier this week, they filed an emergency motion for a stay of the injunction. They filed that in the Third Circuit and was supposed to be in the district court, but that's the least, I think, of the flaws in what they filed. And about an hour and a half ago today, we filed an emergency motion on behalf of these class members, asking the judge to please go ahead and at least provisionally certify a class, and then to make clear that this injunction applies to all similarly situated individuals. Let me just tell you one story which repeated itself over and over again, then I'll shut up, is that we have to deal with translators for all these kids. And the languages, as you can imagine, from these countries are ones, some that I've never heard of, Hakachin, Fur, and then there's Swahili and Arabic and languages like that everybody's heard of. Been very, very difficult. And it's easy to look at these kids who it's hard to communicate with. And you ask them questions, you have to go through the translator, and to think there's not much there. And as you get to know them, and as you get an interpreter who's familiar with what's going on, you start to see the depth in these individuals. And when you think about having lived through the kind of trauma they've lived through, I mean, these are super character building experiences. And so at trial, we put all 6 of our clients on, and they were fabulous. Cassine, in fact, was questioned by the judge, as were a lot of them. And this, you can't script this. And the judge says, what did you think when you heard you were going to America? Because only like 10% of the world's refugees get transferred. He said, happiest day of my life. And the judge says, why is that? U.S. #1. We're thinking, we couldn't have set this up any better. The judge's career Navy JAG, so I thought that he might have liked that. But on cross-examination for all of these kids, the school district's attorney's line was, look, don't you want to graduate? Yeah, I want to graduate. Isn't it important for you to get that diploma, that piece of paper? Yeah, it's important for me to get that piece of paper. Do you understand that if you transfer from Phoenix and go to McCaskey, that you're not going to be able to get enough credits to graduate, you're not going to be able to go to college, you're not going to be able to get a job, you're not going to be able to go in the military, so don't you want to stay at Phoenix and get that diploma? All 6 of the kids came back with some variation of, I want the diploma, but it's more important for me to learn. Because if I don't know anything, what good is that piece of paper? And, it's just, if you can't see the steam coming out of my ears, you can get a little bit closer, and it's been coming out since mid-April. But just to think that here are people who've suffered so much trauma, who are, now finally get a break in life, and then to be treated this shabbily by the school district is really outrageous. So stay tuned. I'm pretty sure the fireworks are not over. So a day in the life of doing some kind of immigration, constitutional, statutory law.
Great. Well, I'm going to ask just a couple of
There's
quick
more to
questions to
come.
make sure we sort of stay on the panel till 1:15, and then for CLE purposes, and then I'm happy to open it up to the audience. But the 2 questions I wanted to ask, one was for sort of Vic and Shayla, based on Vic's story and something that Shayla had said earlier, which has to do with these state law efforts to, in one way or other, restrict or punish the undocumented. Shayla, you pointed out that there's been this cutback because of U.S. versus Arizona. I know Alabama had a similar law. Vic's just shown an example where state law officials are proving extremely hostile to the undocumented. It seems
Ours are not undocumented.
my apologies. Refugees, you're right. They're documented. Hostility towards immigrants. Let me just sort of phrase it more broadly. State law efforts, it's hard for me to believe that the states are going to just sort of quit their efforts to, in one way or other, restrict, remove, do whatever, whether documented or undocumented, immigrants that they regard as undesirable. I guess they were lunatics and prostitutes before, now they're rapists and drug runners with cantaloupe cabs or whatever. I mean, so, but it seems to me that it's not stopping, it's unlikely to stop. What do you imagine the next steps are likely to be from the states? Are they likely to have any sort of success? Not should they, well, I think I'm going to guess the answer to that one from both of you, but what are they likely to do, and how likely are they to succeed at a state law level to sort of restrict and make more difficult the lives of both legal and illegal immigrants? And then, Kate, the question I had for you was whether or not these executive power efforts have any effect on your practice or on practices of firms generally. That is to say, I know it's been enjoined, but are there things that the executive is doing of constitutional import that do or do not have, are or are not important to the immigration bar as it practices?
So, according to the National Council on State Legislatures, every year states, counties, and cities adopt statutes in the thousands that one way or another impact immigrants. Like, this is a perfect example of what, and not all of the statutes are restrictive. So there are also jurisdictions like Pittsburgh and other cities like Dayton that have adopted legislation or regulations to encourage immigration, to give additional service to immigrants. So I want to make it clear that not all state activity regarding the regulation of immigration is restrictive and oppressive. But they all face the same challenges, right? Whether this is within the realm of the states to entertain from people that oppose inclusive pro-immigrant practices. So I think that there's going to be much more litigation regarding this. I think that Vic is going to be very busy for years to come. I think they engage in an important piece of the legislation in the Hasselton case. So there's going to be more because there's not a clear, I mean, even U.S. versus Arizona allowed the state of Arizona to, after stopping someone for non-immigration related violations, detain that person for a longer period of time to verify the immigration status of that person. So there's still a space for the states to regulate immigration, and we don't want to make it in a way that will also bar states from doing and adopting legislation, regulations, and ordinances that are beneficial to the community. So there's some balance there that we're yet to find.
So I just heard last night that the new Attorney General in Arizona has now actually come out and said that they are repealing, or they will not honor that portion of SB 1070 that allows the stops, but it's not binding on local jurisdictions. So it's a
Joe
little,
can still.
yeah, it's Joe can do. Well, Joe's
Not there
subject,
anymore, right.
Joe's subject to some
An
pretty heavy
injunction.
duty judicial sanctions right
Right,
now, thanks to
injunction, yes.
my colleagues there. I don't know, we obviously don't know what's gonna happen. I think the presidential election will be somewhat of a barometer about how strong the anti-immigrant fervor is in this country. I was privileged to be counsel in the challenge to the Hazleton anti-immigrant laws, and that was the first attempt by a state or a municipality. They predated Arizona, where they attempted to use licensing laws in housing and in employment to prevent undocumented immigrants from staying there. And after 8 years of litigation, I'm happy to say that law in Hazleton never went into effect, but it was, 2 trips. It was a 2-week trial, 2 trips to the Third Circuit, 2 trips to the U.S. Supreme Court. At the end of the day, the law never went into effect. This is not an issue that's going to be solved by the courts, I don't think, anytime soon. I think, as you were saying earlier, this is something that has to be changed in people's hearts and minds. And I'm cautiously optimistic, because what I see in the younger generation, so a lot of you folks here, is just a whole lot more tolerance for everything and everybody and people being different. And it's not, you know, and I see it when it comes to LGBT issues, where and we're doing the marriage equality case, and I would ask, you know, young people, I say, well, you know, what do you think gay and lesbian should be allowed to marry? And it wasn't like they were ready to give me a long, sort of well thought out answer. It was like, why are you asking? You know, if they want to get married, who cares? You know, and it's that kind of attitude, because I do think, at least in many parts of the country, there's just so much, you know, we're so much more of a diverse society. I mean, people are out of the closet. You have more immigrants coming. So I do actually think that things are going to get better, but they're going to get better as the younger generation takes over. And, you know, I hope my optimism is well-founded. But
So the effect that the executive actions have had on firm life, we have seen an increase in certain aspects of it. We filed a lot of the DACA petitions, so people who came here as children and went to school and a few other qualifications can be kind of protected from being removed from the United States and are entitled to work authorization as well, which was a big deal because a lot of them were either working under the table or couldn't go to school or whatever the case was. So we've done a lot of that. And the other one that's affected us was one of the more recent ones from last November was, and they started to allow the spouses of H-1B workers, so the dependents of H-1B workers who are traditionally not work authorized. If the primary applicant was far enough along in the green card process, his or her spouse can get work authorization as well. And this was a really big deal because a lot of times you'd have a husband and wife come and they would both throw themselves into the green card pool and see kind of, you know, who got to the front first. But if you run out of underlying work authorization time, then you're just kind of sitting around the house. But these are, you know, well-educated, productive people who just aren't allowed to work. So we've done a lot of those H-4 EADs now, work authorization documents.
Well, that's great. Let's. I think we're exactly at 50 minutes, so we've met our CLE quota. I do want to give opportunity to the audience to ask any questions that it might have. So I don't know. Yeah, question.
Question for Jim. What these students are not citizens, correct?
So it's a mix. It's a mix, appears to be, because the school district has thus far refused to share sort of information about the population that we're trying to get certified as a class action. Our best guess is that it is a mix of refugees and entrants. So we are dealing, by and large, at least in Lancaster, with folks who are here under some kind of official status. So, you know, refugees are here under the.
Not citizens yet.
No, not citizens, but here.
That to her.
Yeah, and
So when you come to the United States as a refugee, after a year of being a refugee, you can become a legal permanent resident. So you become a green card holder that allows you to remain in the United States indefinitely, and in 5 years, you can become a U.S. citizen. It's a part of a path to naturalization. But one of the important things about being a refugee is that refugees are protected by very special regulations that allow refugees to receive benefits and protections that are not available to other immigrants and not even available to legal permanent residents. The U.S. admits around 80,000 refugees a year from a total of 64 million refugees worldwide. And those 80,000 people have a very special protected status to access to benefits that other immigrants are not able to access. So it's a very special protected category, and the U.S. has a special duty towards them and has enabled that through legislation and regulations.
let me just follow up on that, because we were talking before about demonizing immigrants throughout history, and part of the school district's attorney's argument here has been essentially that she asked at deposition, she asked all the kids if the parents were on TANF, right? And then at trial, she repeatedly kept making the assertion, and frankly, they put this in writing now, that these students all come here and they have no education, and they're part of arranged, forced marriages, and they're going to bring drugs and alcohol into the schools, and these are older students, and they're going to be there with the poor young 13 and 14-year-old girls in the school. It's, you know, we're sitting there. You know, these kids just want to learn, right? It's going to take them a generation to get to the level of criminality that citizens get. I mean, it's just, it's unbelievable.
The reason I was asking about the citizenship status was because I was wondering, those statutes that you used, that you did your lawsuit, is there any requirement that the people who are able to benefit, let's say, from the Equal Education Act, is there any requirement that they be of a certain immigration status or a certain, this applies across the board?
Yeah, there's an old 5-4 Supreme Court case called Plyler versus Doe. Everybody thinks is hanging by a thread, but it's been hanging there for decades. And I can tell you, none of the civil rights advocates want to go anywhere close to it. So I think we took it out at the end from our brief because we didn't really need it. There was great language in there, but it made plain that if the kid is here, regardless of their immigration status, even if they're plainly here illegally, they're entitled to that education. And Pennsylvania, I can't remember if it's the regulations or the statutes, actually forbids school districts from inquiring into a student's immigration status.
And that's true of the Title VI argument that you made as well?
I don't know. I'll have to think about that. We haven't gotten there. We kind of focused on EEOA because that seemed to be the most likely path to success.
Any other questions from the audience? All right, great. Well, I personally found this very enriching, and I hope that Vic's optimistic story turns out to be
It's up to you guys.
turns to be true. Well, I will say, I mean, one thing that is quite fascinating is, well, there's one question. One thing that is quite fascinating from Shayla's slides, and one can see this from the literature, it's quite fascinating here. You know, we have to stop all the non-white immigration from Ireland and Italy, is what you see at the beginning of the century, right? Because Irish and Italian aren't white, and right, I mean, the idea of that now is just so weird.
So there was a scale of whiteness, which might be odd for us, especially in the city that has an Italian and Polish and Irish background in its immigration, but there's the issue with the Italians, and there's a lot of discussion in the newspapers of the era and about their being Catholic. So there's a strong opposition to Southern Europe's immigration because those are the Catholic areas of Europe, and there was actually a political party called the Know Nothing Party that was an anti-Catholic political party, and they proposed, among other things, that Catholics could never be Americans because they would always be, loyal to the Pope, and the Pope is the incarnation of Lucifer and evil, but also because Catholics had too many children, and there was this fear that the Catholic children will make the U.S. be a majority Catholic country. And that's still something that you hear when you hear about opposition to Mexican immigration or Latin American immigration in general, is how it might change the religious composition of what is to be Christian in the U.S.
In every corner. There was one last question, and then we'll
Yeah, I just wanted to bring up, because Professor Velez Martinez, you brought up this conversation about societal values, and Vic mentioned, in addition to these types of important litigation, changing hearts and minds. And I wonder if you have any more thoughts on that, because in my experience, there is this animosity, especially towards undocumented immigrants in the broader population. But, and I've always kind of fell back on, but at least refugees are these inspiring stories that it seems like everyone can get behind. And I was discouraged because I, had found out about the case this summer, and I was like, this is great. This is an excellent way to get out information. And then I see things from less open-minded people in my community that post things like this is an outrage because they should just be happy with what they get from where they're coming from. And so that, I think, is a pretty entrenched, unfortunately, perspective from a lot of people. So I'm just wondering if you could elaborate a little bit more on, changing hearts and minds. What is the broader movement?
Yes, I didn't say we were going to get there overnight. And I'm actually glad you brought that up because, we often tell clients when we file a lawsuit, and most of our lawsuits get, some amount of public attention, that the last thing they should think about reading are comments online. Because, unfiltered, uninhibited, and we didn't have to tell them, our clients that in this case, because none of them can read those comments, but the comments in the Lancaster paper, I guess whatever Penn Live is now out of Harrisburg, were unbelievably vile, and we're used to getting hate mail. We did get one message that was, every 5 years we take something to the FBI or the postal inspector or somebody and say, this is weirding us out enough that you should look at it. We didn't end up going, but it was I hope and pray that a terrorist moves next door to you and firebombs your place. And then the things they were saying about the refugees were just like this. So, obviously there is a very strong strain in our country, and it's not just this country. If you look at what's going on around the world, a fear of the other, a dislike of people coming in who are perceived as going to take your jobs, and and of course you got a lot of demagogues who will push that for their own personal advantage. So yeah, all right, I may have to take back my comments.
So, this is a conversation about what it is to be American and what is American to be. And the fear of losing the power of being a mostly white, Anglo-Saxon, Protestant community, it's going to change. According to the census, by 2040, Latinos are going to be the majority of Americans. It used to be 2050, and they changed their progression to 2000.
Latinos are non-whites, is the thought. I saw
Right.
non-whites, like Latinos and blacks.
So-
Well, is that because they have so many children?
Well, basically, apparently, we have a lot of children. But what I'm trying to say is that America, the demographic of America is changing. And in a democratic society, power also should change. And where power rests should change. So I think that the part of this slogan of making America great again is keeping America white forever, which is not going to happen. So the conversation has to include a conversation regarding culture, regarding democracy, regarding power and inclusion, because America is not going to be Finland. It's not going to be a white Anglo-Saxon country forever. Culture changes. That's in its own definition, right? Culture is not static, and it has represented a specific type of culture for many years. It's no longer that. It's not going to be that. And there has to be some acceptance to that, and some conversation, and some space for the sharing in the power that comes with participating in a democracy. And I think that's part of the conversation that will lead to a comprehensive immigration reform, among other things.
Well, on that brighter note,
Yes.
let's thank all of our speakers for today.
Thank you.
Thank you very much for being here.
Thanks again.
Thank you.
Yeah, sorry again about the.
I should have said, and that's okay.